Hail to illegal warriors. This is a breaking news video, and this is not good news if you are a firearm owner in Washington State. The legislature's done something totally wacky, in my opinion, that's going to affect thousands and thousands and thousands of people and doesn't seem to be directly related to firearms to me. It's going to make so many people lose their firearm rights. It's crazy. Stay tuned. If you're interested in firearm rights in Washington State, this is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm has been defending people charged with crimes all throughout Washington State for more than 20 years. We're putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. Now I'm just going to jump right into it. The Washington State Legislature has passed a law that's going to take effect July 23rd, 2023, that says if somebody has a second offense DUI and they get convicted, or even if it gets reduced to a whole bunch of lesser charges, then they're going to lose their right to possess a firearm if they have a prior offense, even a prior reduction within 7 years. So 2 DUIs or 2 DUI reductions within 7 years means you lose your firearm rights, even if there was no gun involved in the case. I'm not really sure what the legislature is thinking. The nexus between driving drunk and not being able to own a gun, maybe it's alcohol, but then why not everybody who drinks doesn't get a gun? I'm not sure, but this is going to have a major effect on the legal system. So I'm just going to go ahead and grab the statute here, throw on my glasses so I can take a quick look at it, which, as you know, I don't normally do on the station, but effective date, here it is, Substitute House Bill 1562, effective date July 23rd, 2023. It did a whole bunch of stuff, and there's other stuff about guns I'm going to put out here, firearms. However, the key section here says that there's a change that amends the current firearm statute that says any of the following misdemeanor or gross misdemeanor crimes committed on or after the effective date of this section, which the way I'm guessing it's going to go is the second offense needs to be after July 23rd, 2023. We can't possess a firearm if we have any prior offense as defined in RCW 46615055 subsection 14, if committed within 7 years of a conviction for any other prior offense under 46615055. So a lot of talking, Lance, but here's what that means. It means that the way I think it's going to work is if you've had a DUI in the past, even if it got reduced to reckless driving, that's a prior offense, negligent driving first degree, a prior offense, or reckless endangerment. So you get one DUI that gets reduced, that's a conviction, or that's a deferred prosecution. If you get another DUI within 7 years and that new DUI is after July 23rd, there's no way out. You're going to lose your firearm rights unless you get that case dismissed or dismissed and refiled as something else. Because if it goes down as a DUI, you lose your firearm right. If it goes down as a reckless driving, you lose your firearm rights. If it goes down as negligent driving first degree, you lose your firearm rights. If it goes down as reckless endangerment, you lose your firearm rights. If it goes down as deferred prosecution, you lose your firearm rights. So if you happen to have a DUI that gets charged after July 23rd, 2023, and you care about your firearm rights, pay attention if you've ever been charged with a DUI in the past within the last 7 years, because if you're found guilty of pretty much anything off of that case, anything that counts as a prior offense, and that's pretty much all reductions that don't go all the way down to an infraction, you're going to lose your right to possess a firearm. It's going to take a long time, years and years, until you're going to be able to petition to get your firearm rights back. So I don't really think this makes a lot of sense. As a defense attorney, guns make bad cases. So, reasonable gun regulation makes sense. But I don't know that this seems reasonable to me, that something that I see no nexus that I can find between drunk driving and firearm ownership when there's no gun in the car. Why would the legislature say we lose our firearm rights in that situation? So what do we do about it? What do we do about it if we're charged with a DUI? and it's a second offense. Well, the most important thing is don't get convicted, right? You're gonna have to fight much harder and demand that if there is a reduction in the case, that the prosecutor actually affirmatively dismiss the first DUI and refile the case as something else if we're going to have a plea bargain reduction. So typically, if we had a DUI and it's a low breath test, maybe we get it reduced lower to reckless driving or lower to negligent driving first degree. Well, if it's a second offense within 7, that's not going to work anymore. That's going to take our firearm rights. So the prosecutor, and they're probably not going to want to do this, the way to keep our firearm rights would be to demand the prosecutor dismisses the cause number altogether that we're cited under and file a whole new cause number that never mentions DUI, right? Dismiss cause number C20388, refile, which is DUI, refile a new case C20389 under reckless driving. Now that particular cause number was not a DUI that got reduced. Therefore, it's not a prior offense under the law. And that means that it would not trigger firearm rights restrictions, is my belief, is how the law will be interpreted. Now, there's a lot of chatter in the defense bar. There is some case law where this may be able to be challenged. I'm sure it will be. But I want you to know that this exists. So what do we know? We know that if you have a prior DUI within 7 years, what does that mean? A prior offense. That means a DUI conviction, a DUI reduced to reckless driving, a DUI reduced to negligent driving first degree, a DUI reduced to reckless endangerment, or a successful or unsuccessful deferred prosecution. If you have one of those in the last 7 years and you get a new DUI, your firearm rights are toast unless you get an exceptional result. So keep that in mind. Don't drink and drive, obviously, but I want you to know this exists, and there's a lot of people that are going to be pretty mad about it. So if you find these useful, please like and please subscribe. More people get the help they need. More importantly, if you're facing a DUI, if you get a firearm issue, whatever you've got in Washington State, feel free to give my office a call. Listen to what happened. We'll identify a way forward. We will be there for you. Thank you.